Now for the second panel discussion for the day, let me introduce you to the panel members, Harish Shivaraman, Mithun Gerahalli, Rahul Raj, Ajit Alex George, as well as Aarti Mane, who will be moderating the discussion. Citizen trying to bring some positive changes to the system to make it more robust, rule-based and equitable. Raising voice for apartment residents for last few years, a member of legal team as well as governing council of PAF. Mithun Gerahalli. Mithun is the founding partner of Gerahalli Law Offices, a leading full-service multidisciplinary law firm in Bangalore, which offers regulatory, advisory, transactional, and dispute resolution services. Litigation being his forte, he provides legal representation to clients across all sectors, including real estate and apartments, and before various legal forums and high courts. Mithun was admitted to the Bar of New York State in the year 2008. He is also a qualified solicitor in the England and Wales jurisdiction. Rahul Raj. Rahul is the director of RM Corporate Solutions. He joined the business in 2019. He has done his master's in financial planning and analysis, chartered accountant, and is doing his research in Indian contract laws. He is leading the entire RM team, which has 22 employees and 100 plus clients from the United States, UK, UAE, and major cities in India. Rahul. Ajit. 13 years of rich and diverse experience in the areas of business development, PL responsibility, and general management. Performance-driven sales professional with experience in building and maintaining a strong market presence of product services handled. Ajit is currently the director of 42 estates. And Aarti. Aarti is a market researcher who loves to run and write. She has been actively involved in issues that affect citizens, including apartment management, waste management, and lakes. She is a community anchor with Citizen Matters.
Sorry, I'll just take a couple of minutes to show something. So in your ADDA, right on the admin side, you can access this. So what we are doing here is we are putting together a marketplace or a list of vendors, partners who are experts in their particular fields. So there was somebody who was asking me about, they were conducting online AGMs and they would need really help on that, how to really conduct them in a proper manner. And if we know any partners who can help them do that. So it is not only that, but there is a host of other partners and experts that we have listed here. So right from your ERP admin side, you can access this. Even in your ADDA app, if you are an admin, you will get this option right on the home page of your ADDA app itself. You can see this. So there is a banner, and click of it, you can go to this list. So there is a host of service categories here, starting from online AGM to pest control, landscaping, accounting, compliance, and there are a lot of interesting other services and experts also who are there. For example, if you want to set up even a preschool in your community, you have vendors and partners who can help you do that. This can help use the community space in a good manner, plus it can have revenue opportunities for you. So there is a host of different such service providers and experts who are listed here. You can check it out. And in case you need any of these services, please go ahead and there's a simple form to fill and we'll connect you with the experts who are there. So you can check it out. I don't want to take any more of your time handing it over to Aarti. This is right there on your ADDA ERP on the admin side.
Hello, everyone. So this part of the program, we will be looking at the legal issues related to handover of a building. And to start with, I'd like to ask our very good lawyer, Mr. Mithun, what sort of constructions need to be registered? For example, in smaller areas, like the old part of Bangalore where you have like smaller sites, like maybe 50, 80, 40, 60 sites, old bungalows broken down, and then apartments come up. So sometimes you have smaller apartments with like 5 flats, maybe 6 flats, 8 flats. which some of them will be owned by the people who had previously owned the land, some the builder takes and they share it and all that. So there was a question raised in the morning as well as to how does one determine whether the apartment needs to be registered? So can you throw some light on that? What is the minimum size that is required for an apartment to be registered officially? And what all comes in? I mean, bigger apartments, gated communities, because until recently, gated communities were not allowed to register. So if you can just elaborate on that. You can take this, I'll just check this.
Okay. Hi, good afternoon. So the question is, what is the benchmark for development to register themselves? The question I would ask is, register themselves under what act? So that's the gray area.
That's what we found. A lot of the people here are
Right, that's the gray area. That's the gray area. So, so what you're looking at right now, the question that you're asking us is basically is post-registration and post-purchase. And I feel the legal, the gray areas right now is actually when you divide the whole cycle of buying an apartment or a real estate in India, you split it into three portions, right? One is pre-purchase, and one is the purchase, that's the handing over, and then the post-purchase. So a lot of people think, for example, RERA, they've only addressed the issues of pre-purchase, or when they're purchasing, what are the things that requires to be done. But it doesn't addresses the issues of handing over or, after the registration and post-registration. So right now, there's Karnataka Apartment Ownership Act, 1972. And there's another act, which is Ownership of Flats Act, which is a regulation, regulatory act, 1972, which promulgates the rules and regulations for the promoter who would, take up the development. So when you're asking me a question, what is a benchmark? Basically, it would correlate to the association, because who is the authority to get the administrations going? So in association, unlike the recent Companies Act amendment, unlike even in Companies Act earlier, there is a minimum person required was 2. You can't have a company without 2, but unless a statutory amendment came into place, so there's also one person, single person entity. So in association, the problem is, before all of this RERA and everything came in, normal notion would be an association would probably be registered, by virtue of their respective sale deeds, and then they would be left to look out for themselves. So then they try to figure out things, what needs to be done, and that's why there's so much of mess, because everyone keeps doing whatever they like. So they register themselves under the 1960 Act, that is the Karnataka Societies Act, which is a general act that is available in Karnataka for all kinds of association under Section 3 of the Act. Section 3 is basically, it says cultural, religious, and so on and so forth, but doesn't cover maintenance, doesn't cover apartments. So, the Karnataka High Court said you can't register yourselves under the Societies Act and collect maintenance. So then there is Cooperative Societies Act. Cooperative Societies Act, again, is a minimum number of persons, that is 7, and then this 13. Then they have their own regulations regarding regulations of what are the kind of members that is required to be part of the association. So that's also not an ideal act. So right now, currently, I think most of them are registered in the 1960 Act, that the Societies Registration Act, which is a general act. So when you take that into consideration, it's basically 7% is the minimum requirement, right? So then comes the other act, is the Apartment Ownership Act, which is the onus lies on the builders to get the deed of declaration. So basically this act of 1972, Apartment Ownership Act, is an opt-in act. Unless you opt in to the act by way of registering a deed of declaration, that act is not applicable to the building. So basically, unlike like the Ownership of Flats Act, which is applicable to the promoters, it's a general law which is applicable to all promoters who would commence any kind of development in Karnataka. But Apartment Ownership Act 1972, unless and until you register a deed of declaration in a concerned sub-register office, that act is not applicable to that building. So it's not default. So currently, what happens, some apartment buildings, promoters do register the deed of declaration. There is a document called deed of declaration which is registered in the sub-register office. That's the Form A as per the Act. And there's Form B where you take individual declarations of the apartment owners who would sign saying that I'm abiding to the declaration that is registered by the builder. So the Act itself, there is a lacuna because the Act says that for this Act to be applicable, this particular building has to be registered under the deed of declaration. So once you register the deed of declaration, then by virtue of the Act, an association is formed. And again, when you talk about association, it goes back to 7-member persons. So technically, when I answer your question, right now the threshold is 7 members are the basic requirement. And then if you go to the Ownership of Flats Act 1972, Section 11 of the Act says that the builder shall hand over the documents and the property to the association, but doesn't mention the timeline when it shall be done. It says whenever it's ready. So when you say whenever it's ready, let's say they start registering today, and there is 7 purchasers who have registered, then can I say that because there's a minimum number of people who can have an association, so you can have the handover done at that threshold. So there's no timelines specifically mentioned in the statutes. So of course, if I would conclude answering to your question, what is the threshold? It has to be 7 as of now. But as far as I remember, the Act in Delhi, Delhi apartment rules, there was an amendment in that rules because some people filed a PIL stating that there were a lot of issues with the earlier Delhi Apartment Ownership Act, because entire India has Karnataka, similar to Karnataka Apartment Ownership Act, there is Apartment Ownership Act, probably 1972 and so on and so forth. All the acts are pari-materia to what every state has adopted that act. Every state has that act. But the states have further amended to include to address the gray areas. And what Delhi did was they stated that you don't have to register deed of declaration. By act itself, any building which is having more than 3 units automatically comes under the act. So then what happens right now, most of the people come to us asking, what do we do? Because they're like, we're in no man's land. We've been given this building. We don't have an association. We don't have consensus amongst the members to form an association. We have no consensus to the managing committee, and there is no cooperation from the other side. So what do we do? So the only solution right now is if they can make this act applicable by deemed construction of the building. With 3 or more units or 4 more units, whatever the threshold they want, then automatically that act itself is applicable once the handover is done. And so, this question in future will not arise. When do we start the whole question of forming the association or having this registration of Apartment Ownership Act or the Ownership of Flats Act? So if they can make it deemed provision, then it would be a simple provision.
So, thank you, Mithun, for detailed explanation. But as our view from I represent Bangalore Apartment Federation, and our view is actually the act, that system that we have is pretty clear on that topic. When we see the COFA, even RERA also brought in 2020. RERA also brought in that COFA has that practice practiced in the state, law practice in the state. So if you look at as good as I remember, Section 3H of COFA, which says the developer or the builder has to give in writing what is the nature of association to be formed, and what are the rules and regulations governing that building. That is actually that section 2H of 3H of COFA says. And when you go through the other act, even be it RERA or COFA, we say there are two kind of associations. One is group of owners, which is actually heritable and transferable property, registered as heritable and transferable property. Another is cooperative society. So by looking at it, these are definitely is a distinct entities. So then we can assume that, of course, group of owners is, as is mentioned, it is a heritable and transferable property, and cooperative society is the one which hold the entire property and owners are holding a share in it, which is actually a practice, a practice in Mumbai, right, and Maharashtra. So if you opt for heritable and transferable properties, which is actually the system in Karnataka. Almost 99% of apartments are actually conveyed through that method, right? So maybe a very few countable number is under Cooperative Societies Act. So now when you opt for that particular system or association, then automatically the law governing that system is Karnataka or Apartment Ownership Act. Right, is automatically comes in. And Rule 6 of Karnataka Apartment Ownership Rules says, it says actually the parties to the deeds, right? So the parties to the deed says, the first party, that means the person who convey, who sell the property, is the person who executed the deed of declaration. So it's very clear, it's before the first sale, the deed of declaration, which is nothing but the definition of the entire property, right, has to be in place. Then start selling it. But unfortunately, as Midun rightly pointed out, that is not happening in practice. That is the main mess that we have here. So once actually that law is in place, the system is in place, but we are not practicing it. So that is the problem with the administration of the practice. That's what I can say, administration of the system. So once we correct it, I think we can easily address this issue. I think if you look at some apartment which is came up in early 2000s, right? Major builders like Mandri, Shobha, and other things I have seen. They started selling it. If you look at the incumbrance of that apartments, they started selling the first apartment after the execution of the deed of declaration, right? So one of our previous governing council member in BAF, was in such a building. So, so that question of when to form association is already done, and also the association is defined in our Karnataka Apartment Ownership Act is group of owners acting together according to a bylaw, right? So it's clear. So before you sell the first one, making a first sale, that association has to be in place. That is the system that we have, which unfortunately we are not practicing it. So that's what my take.
One question around that, sir. Please. So you mentioned about association has to be in place before the selling of a unit, right? How can association be there without selling of a unit? It is only declaration, right? You are talking about declaration, not convenience, please. Because when you are saying declaration, what is the deed of declaration?
Actually, what is association? What is association? Be it.
People coming together.
That's what.
Where is the association? 7 people getting registered.
Not 7 people. Actually, as per the deed of declaration, every owner has to be there, right?
Without you mentioned without selling first unit, the association has to be registered. DOD has to be registered. What you mentioned.
Yes.
Right. Without selling, how can they be owners?
Before selling, promoter or builder is the sole owner.
So he is the one who declares whatever as per the guidelines.
Before the selling, the property has to be defined. See, when you are purchasing an apartment unit along with the interest in the land, you are purchasing a portion of that, entire property. So before that, this thing, the entire property has to be in place. The definition of the property. If I take from the last, the panel discussion, that the registration of, handing over document and other things, it is nothing but a deed of declaration, right? So here.
Defining without consultation with the home buyers.
No. Actually, he is selling the property after defining it. What is that apartment property is all about? What it contains, what is the compliance associated with it, and all stuff is ready and giving to you, selling it to you after that. That means before you purchase, you know what is that building all about. What is the restricted areas, what are the compliances it has, what is that rights you have, and what is, rights in the sense, I'm not talking about the bylaws, but actual, that property rights that you have, everything is clear in it. Even tabulated and, as per the Apartment Ownership Act, actually it has to be tabulated and, summed up and, in a table, right? So even if that were practiced, then today we have seen, many of the undivided share are not allotted properly. Right? So all these things are happening because of that we are not practicing the law.
So when you say we, is it builder or Mumbai?
I didn't get to that.
When you say we are not practicing,
No, this entire system is not practicing. That is it starts from the developer. It starts from the developer.
one example I wanted to give you, because when I purchased in one of the builder, I don't know who quoted, he has not shared the deed of declaration till today. We extracted from the government authorities and discovered only 4% of the purchase SPU is given as a deed of declaration as undivided share. Then we are litigating in the court of law, right? So I think what you have said is not practice, it is not system, it is a builder side.
Yeah, of course. That's what, we are all stakeholders of the system.
Yeah, actually, because the deed of declaration is made prior to selling the buildings, the flats or the homes, when the sale deed is executed, there is generally a reference to that deed of declaration in the sale deed. But
actually, once it comes to Apartment Ownership Act and DOD is executed, it has to be further sale has to happen through apartment deed. Actually, apartment deed is a specialized form of a sale deed which has certain conditions, right? So that even how many of us, getting conveyed through an apartment deed? Right?
yeah, so the thing is that a lot of
The builder is not mentioning what is the undivided share and is it getting registered in the subject.
yeah. So see, we had a question this morning as well.
Carried out and ED is investigation on this.
Right.
I don't know to quote it, but ED is investigation on this case.
Yes. See, we had a question this morning as well, where the deed of declaration and all has been filed by the builder. But finally, the association is made using the Societies Act. Can this be rectified? Okay, see, I'm not so sure how shall we do this, because this is a big issue. So we have one situation where the builder might have submitted the deed of declaration. After that, what is it that flat owners need to look at? Because a lot of the people here probably have bought flats. They're probably living in apartments where the deed of declaration may or may not have been filed. So if it has been filed, what is the process? If it's not filed, what do they do? That is one question. The next question is, there are apartments where they are currently running on the Societies Act. Is it fine for them to continue like that, or do they need to change? Whoever can pick this up, I'll give the mic to Rahul, because he hasn't spoken now, and then we'll move.
I can pitch in later.
Thanks. So, I mean, the deed of declaration, as per there are other discussions were going on, but I think RERA states very clearly when the sale deed is executed or majority of the sales deed happen, then within 1 year, the association has to be formed by the builder. Is that what RERA says? So there is no confusion regarding that. It's the responsibility of the builder. And how it will go continue, that is the next question. And what point of time we have to initiate it. That's a major question going on. And the second question is regarding whether we can run the show without forming an association.
Not without forming an association, or without
1972
going
Act.
under the 72 Act. Yeah, because I think a lot of the people are worried about that.
KSRA, without many of us are in 1960.
Yeah, so many of them, I mean, the existing registrations are in 1960, then, moving to 1972, which to comply with the rules and regulations. Yes, many associations are running, but it is against the law that we will be discussing in detail.
So, in fact, as far as KSRA is concerned, since 2018, that court order has come. Karnataka High Court has clearly told, actually even 2019, that in writ appeal, that again affirmed, that that KSRA is not applicable to apartment association, because it is in fact meant for some a few things which is actually mentioned in the objection reasons. And actually, if you see the conceptual ways also, we would like to see, conceptually rather than the law, because the lawyers will see from the law to that entity, we are in the reverse. So if you see the concept wise, our concept is that society is in fact a entity which is actually, it is not about the property, right? It can own the property, it can do some, some functions, but the volunteers associated with it are not interested in those properties, right? BAF is registered under KSRA. So even me or any of our colleagues in BAF, even Gautam, none of us are interested in the BAF property, right? BAF can asset, may or may not have asset, but we don't have interest. So we contribute for that good and move away, right? Somebody else come in. But when you come to the apartment association, it's all about the properties. It's a group of property owners. So this is the basic difference, conceptual difference between these two. So that is the one, and as far as this KSRA issue is concerned, since the High Court has already clarified, and every court order, if you are judgment, if you see, there, time and again, they have last 4 years, they have advised go and register under KOA in every such judgment. And what happens to that KSRA association is, in fact, the bylaws of such associations is not binding on the members. We are still aware, even from 2018, since the court order came, Department of Cooperation every year has issuing the circular, don't register. And I am aware of that, apartment association even registered last year under KSRA. Same registrar will get it registered. Right? Even many of you are even submitting your annual returns also, and registrar is happily accepting and giving their certificate, right? Which he is not supposed to do. Even a few months back, a case came to us where a registrar is actually issuing notice based on a complaint of a resident, issuing notice to the management committee, which is he don't have any right, right? He can only maximum do some dispute resolution to an arbitration, right? So. I don't know why, law says something, our system says something, and that that's what, it's beyond explanation. So, but
I think that's very important. Because we know the system how it is working now. And
we have clear guidance. We have given.
You have to take up these issues and work towards it to make it practical for home buyers.
Definitely.
In our case, actually, I'm from Shobha. The same thing, date of declaration was in place. KO 1972. But our group of 4 members, they registered the bylaws in KSRA. And after 9 years, we came to know that KO itself is not registered. It's a deed of declaration is registered by the builder. What is the conclusion over there now?
So please speak using a mic, because many of them at the back are not able to hear. So whoever is, please raise hand.
Hello.
Mic will be passed.
Hello. I am from Shobha Nagsandra, Shubha Shetty. So we had the same example, we had a deed of declaration in place, but our ad hoc committee, they formed bylaws in KSRA 1960, and we are paying 80,000 rupees. So after 9 years, when I became the president, I came to know it's wrong what we had done.
You can change. Anyway, that is okay, because since your deed of declaration already in place, that bylaws are binding on you. KSRA, bylaws are not binding on you, of course, but apartment and DOD, whatever the bylaws are there, that is binding on you. If you have, you can have you can revisit the bylaws. If you need some changes, update it, and then amend that, bylaws in the sub-register office and continue as per that.
After KO, suppose after KO, do we require to go to the registrar and submit the account?
Not at all. Not
annual
at all.
general meeting?
Nothing.
Audit?
Nothing.
So we have to ourselves audit that.
See, you have to see what is actually a declaration do. It is in fact, the all owners coming together and declare that property. Actually, it is actually declaration is not something is brought by Karnataka Apartment Ownership Act, right? You can find it in the section 17 of Registration Act 1908, right? It's almost 1908, 64 years before that KOA came to effect. So there also a declaration is actually like a declaration suit in the court, right? Why that is required? When the ownership is in question, it's not very clear. Then the owners has to come together and declare that property as to make the title clear, right? This is our property. All owners has to come together and do it. And that declaration is actually create an encumbrance as well, right? So that is what this Karnataka Apartment Ownership Act, in our view, is in fact giving a structure for that declaration, because Karnataka government has not notified any such declaration format in any other case. So.
Just a minute. You can go back to the yeah. So see, now we need to arrive at some sort of conclusion, right? So we have people who are registered under KSRA and who have a deed of declaration which the builder has submitted. What are the steps that they follow? You can help us, Gautam? Just take the mic.
You have registered in the registrars of societies. Yeah. That is every year renewed. Now you can go back and tell, I want to come out of 1960, give an application, you can come out of 1960 and continue with 1972. Yeah. That is the process.
But we have
got to come back because you are paying, otherwise you will become a defaulter there.
Yeah, but we have got a notice from one of the resident complained about our not working, association is not working properly. Because these people in the starting were formed the association. They are mentioned in the book, unprinted book, which was not at a seal of the registrar or own KO, nothing. They had registered with the KSRA. And now the registrar is given for a re-auditing. Last 10 years. It is possible.
KSRA, I mean, district registrar.
District registrar, yeah.
Issuing a notice to you for re-audit.
Yes.
Serve them their copies of the High Court order. That's all I can say.
No, sir, he's telling audit. Audit report.
Re-auditing.
That's what, no. If that so a district registrar sent an apartment association any notice, give them a copy of the High Court order.
They are still in 1960. They are still in 1960.
That's what, no. Serve a copy of the High Court order and their circular, the Department of Cooperation circular. That is more than sufficient.
So that means
they have no authority to send you. That's it. Simple.
So that means we don't want to submit
the
auditor statements.
Even if you submit legally, there is no standing, right? They don't. They are not authorized. If that act is not, is not there, High Court has clarified it. Then on what ground registrar is accepting it?
It's a word of an issue, right?
Okay. So.
I just, Midun just let Midun complete. 1 minute.
So. See, there is this major mess that's happening between KSR Act 1960 and 1972. The reason why 1960 comes into place is it's a question of deeming fiction. So an association cannot act as a group of owners in a lot of places because you can't file litigation sometimes because you're not an entity status. So like a corporate company, unless and until you have a deemed status, a corporate entity, you can't sue. The right to sue is not there. So why people go to Societies Act is so that the association gets an entity status. So a lot of times in between the period of occupying the premises and until taking the handing over, you're in like the no man's land. Because even if you want to file a suit, you can't file because there's no association or an entity that's in place. So what happens a lot of times, you can't coordinate with a lot of people. A lot of times I have seen people end up forming an association at least to have a cooperation until they take handover from the builder. Sometimes the handover never happens, sometimes the association is never formed, sometimes the deed of declaration is never registered. So they continue under the Societies Act. Now, as Mr. Gautam said, currently what is happening after the Karnataka High Court judgment where the Chief Justice confirmed the single bench order. The single bench order was basically nothing but a litigation between one of the members and the association, which ended up in the courts because there was an order of the district registrar. It was an inter-dispute which ended up in the court where they challenged the fact that this association that is registered under the Societies Act is illegal. And it should have been registered on the Apartment Ownership Act. And that's where I stared. The problem is, Apartment Ownership Act 1972 says all the owners have to come together. When you have all the owners coming in, technically you can't form the association. So you can't register the deed of declaration. That is why in practice, normally in all the big builders, when they start selling the first sale deed, they have a deed of declaration that's in place, right? So in the agreements, they mention that you are deemed to be an owner of the association. So there's a deeming fiction. See, it's always important to get deemed fiction, because see, it's just not me and my partner, right? You are hundreds of people. Getting consensus amongst the people is the worst. It's a nightmare. So I always end up dealing with people because they keep coming back months after because they're not able to get the consensus amongst the people. So that's why when I stressed initially, they should have this deeming fiction. See, though every act provides for an association to be formed, it has to be formed within 1 year, all of it. But who is complying? Who is enforcing? No one is doing anything. So what happens is, you don't have a deed of declaration, you don't have an apartment association, so people end up doing under Societies Act, and the Chief Justice has said this, has confirmed the order stating the Societies Act is illegal because Section 3, as I said, does not cover the ambit of maintaining apartments. So I have done a couple of this handover and switch over from 1960 to 1972. I'll tell you what the problem is. There's always troublemongers in the association where people don't want to cooperate with the MC because they have some other issues. It's nothing to do with the property, right? So they always say that we don't want to move to 1972 Act, I'll file a suit, I'll file this. So what happens in the practical scenario, MC doesn't have time to deal with all this. So they're just waiting for the handover to next MC. So it becomes a musical chair. So the problem keeps going and going and going, and it never ends and stops. So the only problem is how to have a switch from 1960 to 1972, how to get the association in place, how to get handover in place. All of this has to by way of statutory provision where everything is a deeming fiction. It's like, once you register an agreement, the deed of declaration has to be done. Otherwise, you can't sell the property. You can't register the next agreement. Unless they do that, they can't register. So they have to make it a compliance. So you do that in an agreement, then you ensure the deed of declaration comes into place. And then by an act to get an amendment that it's a deeming fiction. So as soon as you construct the building, there is an deed of declaration in place. It's only a matter of compliance. So when it comes to matter of compliance, it's the minimum number of people should come together, have a meeting on the first AGM and get the people in place. So you skip a lot of things. So here again, the High Court has said that the Societies Act is illegal, but it has not said what happens to the current society. So major issue right now is not that we keep talking like this. We need the government to be in place. So if BAF has to do something, policy has to change. So if unless and until policy doesn't change, you're just going to keep talking and having conference over conference, meetings over meetings, discussions over discussions, issues are just going to be raising. Nothing is going to happen because no one has a time to go to court. No one has a time to go to civil court. As long as you say civil court, they say beda bidi. So it's next MC's headache, not my headache.
What we did was we called an AGM. We got sanction to register under 1972 from the AGM. So authorization was given to the management committee to do the registration under 1972. DOD was not done by the builder. We got the DOD done by the builder. We got the bylaws registered in the sub-registrar office. That's the process we followed. And yes, we didn't have the buy of all the residents, but in the sale deed it is written, the association word is written, not the society. So whoever is buying the house is bound to be the association member. So that is what has happened. What we
that is comply with that that COFA Act. Actually.
Yeah, something we got it done like that. Yeah.
You know what? We just continue. Yeah.
Just to, when you say somebody bought the flat, they are the association members. It's not like that. If they have paid their membership for the association, then they are part.
There is no membership fee for KOA 72. Membership fee comes with shareholding in 1960 only.
Right. If somebody is registered in 1972, are they part of the association?
Yes, automatically. Automatically. By default it is.
Yeah. All right. So.
Because RERA mandates in some of the latest verdicts, RERA is giving order to form an association under Karnataka Cooperative Societies Act, not in 1972.
Because you see the object of the Cooperative Societies Act does not include the word apartment. See, any act has to have an object, and the object has to encompass what it is purpose for. cooperative societies is only formation of cooperative societies for the purpose of financial, banks, religious and other purposes. Apartment maintenance, apartment issues is never part of it. And
No, there is Mumbai is Cooperative Housing Society Act. Cooperating society is different, cooperative housing
So
society.
here,
we don't have that here.
if you are forming a cooperative society in a complex which is actually conveyed as heritable and transferable properties, that will become a voluntary organization, right? So a voluntary organization means a cooperative society of forming 10 people need to form the cooperative society. Now you have a 100 unit complex. So, and under Article 19, there is forming an association is your fundamental right. So nobody can stop you from forming association. So in a 100 unit apartment complex, 10 associations comes in. Who owns what? Who will maintain what? So that is the problem with the voluntary organizations.
No, that cooperative societies, I'll tell you what happens in Maharashtra.
RERA is giving orders to associations. For example, monthly serenity, I want to quote here. In March, RERA as chairman has ordered saying that association need to be formed under Karnataka Cooperative Societies Act.
See, that is if that associate is the complex is actually in the cooperative society as a the entire property is owned by the cooperative society and owners are shareholders, then definitely it is under cooperative society. It is very clear. It is a cooperative society. But if it is actually conveyed through as a heritable and transferable property through a sale deed, then KOA comes into picture, cooperative society note. So these are the two distinct branches, emanating from that COFA, right?
KOA, you mentioned Form A and Form B, I believe. So you said that, okay, I mean, in his case, this was my question. He has issues, for example, with the Form A. I mean, he's saying that the deed of declaration which was registered, there is basically unacceptable stuff. I mean, there's a 4% stuff only. So he's not willing to accept it. So obviously Form B cannot be done. Is there any other way out? I mean, you can't say that he is being a troublemaker because
we have
he has a valid case here not to accept the Form B.
No, not only that, there is a fundamental difference why we went to RERA because the deed of declaration is done by the builder, not by the home buyer.
No, deed of declaration is by the builder.
Deed of declaration done by the builder. Whatever deed he has done, he has not shared with the home buyer.
No, see,
that is
what
your
he's
right.
saying is
Yes.
that the deed of declaration is not declaring the whole property, he says. I think we'll have to take your individual case.
It's a classic case study. It's a classic case study. In deed of declaration, he has mentioned 6 blocks. What is the number of blocks that I am going to construct? What is the square feet I am going to construct? What is the Schedule A property, Schedule B, C, everything is mentioned. And also the rules and regulations of how apartment association need to be managed. Why builder has to take care of apartment association management without involving the stakeholders, which is the home buyers?
No, that is part of the requirement. You have to do it.
That
So
is
the builder...
that is actually as per that, to comply with that section 3H of COFA, in fact. So it is clearly says that, it is actually that nature of association and also the rules of engagement has to be clearly, informed to the prospective buyer in writing. So to comply with that only, you can see every sale deed executed in Bangalore, Karnataka, you can see that, that you have entitled to form an association under Karnataka Apartment Ownership Act. This line will be there in every sale deed. It is to comply with that, nothing else.
See, the thing is, as
But
a buyer,
here's the case,
as
I
a
mean,
buyer,
for
if you are
example,
going to buy a property, then you should have.
Yeah, I thought you said the person holding the mic will ask the question actually. Yeah. So my question is like, for example, your Form A, the deed of declaration, let's say builder is saying, okay, I've done every single amenity I promised, which is not actually the case. He's gone and registered it. Now, should I come together with others and say this is automatically applying and I should sign the Form B? I mean, how do I register the association? It's like, catch-22 situation. He's done the deed of declaration, but there's problems with that.
See, the problem, I'll just explain what he's trying to say. There's a deed of declaration and he has declared certain things and he has not met all those things and now they're asked to sign the Form B, but because the deed of declaration is not fulfilled in totality, they don't want to sign the Form B. So they cannot form the association.
So what is the
That's
out
what
of
he
this?
says.
I do want the association to be formed.
Yeah,
without
of
signing
course,
the Form
you
B.
have all the rights to challenge. If you are, if the builder is not met the expectations that he is promised to you through the sale deed, right? You have all the rights to challenge that one, and you have the right to get it done. But as far as Form B declaration is concerned, it is, I don't know why in that our legislatures, has made it a voluntary, because this act itself is not a voluntary organization, right? It's a statutory organization. So Form B makes it a voluntary, aspect to it, bringing a voluntary aspect to it. I have seen some other states also. Most of the states do not have this Form B, and Gujarat and all has done, along with the sale deed itself, they are attaching that Form B and doing it. But in Karnataka, it's actually Act. There is a provision that, if those people who are not submitting the Form B, their rights has to be captured separately.
Correct.
Okay, so that is, but the problem is, all that, whatever the bylaws and everything is written, executed, is applicable to you, even though you have not submitted your apartment to that Act. Right? So this is the one issue is, in fact, it's not, sitting in that concept correctly.
So how do I form the association without agreeing to B? I want to form the association without basically agreeing to this faulty deed of declaration.
Let me answer that question practically. Okay, theoretically, this is the answer. Practically is what Mr. Gautam said. You first call for an AGM, talk about the objects of the Act, mention that you're being registered in the incorrect Act as per the recent judgments, say that you want to adopt the the already existing Apartment Ownership Act, ensure that you have the 21 days notice so that your meetings are not invalidated later. Right. Follow all the procedure, get the AGM in process. In AGM, all of the owners ensure that you give issue notice to all of them. Ensure that you have the quorum on that day. Adopt the bylaws, adopt the deed of... Yes. So 21 days before, you ensure that you... See, this whole process will at least 3 months, right? So I can't give you entirely steps by steps. I'll just brief you. So ensure that your 21 days notice goes with the deed of declaration, your bylaws, everything that you're going to adopt in the new Act, and have the deed of declaration as per the Apartment Ownership Act. So the Apartment Ownership Act is the Bible for the deed of declaration, and it has the basic set of bylaws and the Act. So anyone who's adding their own provisions in their own bylaws will be invalid. Right. Any bylaws that is passed by any of the association or the builder, which is contrary to the Act or the sample bylaws that is comes along with, that's Form A, that comes along with the Act, any such bylaws is automatically invalid. Right? So you ensure that you follow the 21 days process, you update the bylaws and everything, hold the AGM, adopt the bylaws. The only problem is you'll have to register the deed of declaration. That's what the law says.
And the deed of declaration is what
I'll come to that.
With, not the bylaws, let's say.
No, I'll come to that. So the deed of declaration is Form A. Bylaws by the Act is an annexure to the deed of declaration. So let me finish. So you have the bylaws, you have the deed of declaration, you have the bylaws. Technically, this is Form A. Form B is where individual persons have to give a consent to that. Now, practically, when you're trying to do it in between, when you're trying to do this whole handover from the 60 to 72, 99% of the chance you can't have 100% compliance. That's where the issue is. So tomorrow, if someone wants to go challenge that, saying that all the owners are not there, then I can't help it. Only thing is, practically, this is all you can do. So then you get your AGM to pass the authorized person who will go register this Apartment Ownership Act in the concerned sub-register. 90% of sub-register doesn't have any idea what's going on. You will have to go sanitize him what this whole process is. The best part is get a sample deed of declaration which is registered elsewhere. Take that and show it to him. Then he'll say, okay, per apartment basis, you have to give 200 rupees, 300 rupees. He'll do all of that natak. Then you have only tell him it's only 200 rupees registration fees, which he'll not believe because that's probably worth crores of building. So you register it, get the authorized signatory, make a seal, get the signature done, get the registration out. So then you have your deed of declaration registered. Then technically you need to form the members, right? So for that you have another day where you call for people to have their nomination, blah, 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 all of that. So you need something more or this is enough?
All right, thank you.
Sir, whether... Hello? Sir? Sir, please.
Hello,
Ma'am, yeah.
we just continue here. I need to give Ajit the chance to talk. I'm
Just
so
a minute,
sorry
one
because-
question, ma'am.
Because
I just
we've
want to
not
know
given him-
if the owner who don't declare the Form B, whether he is having the rights to contest the...
We'll have this gentleman talk first.
Yeah.
And then we'll pass it on.
Please, a single...
Yes,
Sir.
Ajit.
Sir, we have an
Sir,
exclusive
Sir.
Q&A session after this. Let the
Sir,
panel
last question, sir.
Deed of apartments, how it is related with deed of declaration?
See what happens, this question is a chain link question, so we'll have it as a question.
Yeah. So there is
I've
after
given
this
basic
panel,
Q&A.
we can continue this panel we have. So please
Yes.
hold on
Happy to answer,
it
but
and
let him
request
also
all of you
talk
to
it.
please
Yeah.
hold on to your questions.
Hi, so it is better to actually get it registered through 1972 Act so that there is actually a blueprint given by the builder. What is
Hello,
the built-up area?
please don't have inter-discussions there. Yeah,
What is
just,
the UDS? How many towers are there? What is the time duration for development? What is the size of the clubhouse? What is the size of the areas which is relinquished to the government for public roads and parks? All those things are predefined as per the law. The only thing which the consumer need to make sure that it is on abiding with what is declared before, because this is actually decided, printed and registered before sales. So as a consumer, you need to make sure that probably once a quorum is done, probably 50%, 60% sales is done, need to actually revisit the blueprint and see, make sure that at least there is a 99% match in the execution on STP, the sizes of the capacity being estimated at the beginning and what has been implemented, probably the size of the kind of deviations, the kind of fire norms being enabled. All those checklists, there has to be a checklist where you actually make sure that 90% is matched, then move forward for getting all the members onboarded into it.
yeah. Now, this KSRA and KAOA, we will take now in the question and answer sessions because we have a few more aspects which are involved with the legal handover of a building. There are many apartments which are like in the back of beyond where there are no civic amenities. So when the builder sells the building, he generally puts up like a grocery store, Iron Man, just for the convenience of the people. Phone exchanges are another one. What is the legality of this and what should residents be aware of when they take over? Because we have experienced that, BESCOM suddenly will come and say that this is commercial. Your place is a residential place, but you have set up a shop and it is not right. But then the shop has been running for so many years. The builder is the one who put it. Now they're not going to accept that. So how should associations look at these things when they are taking over from a builder? Who will go with that?
See, typically when you start construction in any of the projects, you're supposed to have a temporary connection. And any project beyond residential for your clubhouse, or if you have any ATMs or any kind of grocery shops inside, all this has to be a separate connection which is under commercial head from a BESCOM. So obviously, when you take over from the builder for any projects, you should make sure that the residential is actually on a permanent power, which has a clearance NOC from BESCOM. Also, you should have a separate connection for your street lights and any kind of commercial activities happening inside the premises.
As
But
far as,
clubhouse is not really commercial, right?
As far
It's
as the commercial term of the BESCOM is concerned, there is a clear notification from KRC that 25% if you are consuming less than 25% of the total power in such activities, that should be considered as a domestic. Right. So if you are going above that ceiling, then of course the commercial terms comes in. That is a clear notification actually. But Gautam, actually that we are taking up with the KRC and all, right, the meeting.
The KRC says 25%. In that KRC document I have clearly read, it identifies gym, clubhouse, swimming pool, all those things will come under that. Those days they have not mentioned the kiosk or shops and all. But the discussions has happened with L&T South City also. They were put a notice. They went back to the MD and it was withdrawn. So basically, you will have to look at your connected load, and percentage of it what is used for others. Preferably you have separate meters. If vendors can put a separate meter, that is preferred always. But no, BESCOM cannot put a penalty on you for making it as a commercial unless it is more than 25% of your connected load. But KARC rules is clearly written. BESCOM will not give another rule. They follow KARC guidelines. They will not write and give some demand was there. Why don't we get a letter from BESCOM? BESCOM follows KARC. While KARC gives the increase in pricing, next day billing also increases. They will not even notify. Afterwards they notify that, okay, as per KARC, we are increasing the prices. So let us be clear, as Harish said, 25%. Now that 25%, what we have asked again is when we meet BESCOM, let us identify these also come under that 25%.
Can I add something to this? So I've fought cases for clubhouses where there's a back billing of 50 lakhs to 1 crore. So what happens in the apartments is basically there are two aspects to it. One is your apartment and one is the common areas. The dispute is with respect to billing of